A very good evening to you, ladies and gentlemen. I am happy to welcome you to the 16th webinar of Series 6 on Basics of Law, titled Arbitration Act, a Practical Overview. This is the 49th BSL webinar for the years 2025-2026. This webinar series is organized by the Webinars and Legal Symposiums Committee of the Bar Association of Sri Lanka. I would like to take this opportunity to thank the chairman of the Webinars and Legal Symposiums Committee and the president of BSL, Mr. Rajiv Amarasuriya, the co-chairman, Mr. Chaturaya Galhena, secretary of BSL, and Mr. Pasindu Silva, treasurer of BSL, and the conveners, co-conveners, and the members of the Webinars and Legal Symposiums Committee. I would also like to extend my heartfelt gratitude to the executive committee of the BSL for the support and guidance. For today's webinar of Arbitration Act, a practical overview, we have with us an esteemed panelist, Mr. Vasantha Fernando. Mr. Fernando is an attorney at law and senior counsel. He holds a master's in law from General Sir John Kothawala Defence University, emerging as the batch top LLM 6th batch. He also holds a BSc in Business Administration Special Honours 2nd Upper Degree from University of Sri Jayawardenepura, FCMA Sri Lanka, ACMA UK, Postgraduate Diploma from UK, and AIPA from Australia. I warmly welcome Mr. Vasantha Fernando, attorney at law, for today's session. To moderate today's session, we have with us Mr. Raman Veerasinghe. Mr. Veerasinghe is an independent legal practitioner specializing in the areas of intellectual property, privacy law, information security, data protection, company law, environmental law, and commercial transactions. He holds a master's in law from the University of Colombo, a BSc in information systems and management, a LLB in law and a diploma in economics from the University of London, and a post-attorney diploma in intellectual property from Sri Lanka Law College. I also warmly welcome Mr. Raman Veerasinghe, attorney at law, for today's session. And without any further ado, I invite him to commence today's proceedings. Over to you, sir.
Thank you, Mr. Fernando, and thank you, Isiri, for that warm welcome. Sir, Mr. Fernando, as you know, arbitration is a rapidly growing area of law. It is, as what we call alternative dispute resolution mechanism. Could you, in the way we proceed on today's webinar, let's start from the very foundations and work our way up to provisions of the Act, such as enforcement and so on and so forth. In your opinion, first, just explain to me what is arbitration and what are the benefits of arbitration over other dispute resolution mechanisms?
Yeah, Revan, thank you. And thank you, Isiri, for the introduction. It is like more or less as you requested, this area of arbitration, if you look at, this is an area which has become very popular as at to date among the commercial sector as well as international arbitrations wise internationally. So why arbitrate, more or less? So as you said, it is an alternative dispute resolution process which has so much of advantages. One is the key most important advantage is the confidentiality. And that is where you will not get a public coverage for the arbitration hearing. Now, if you come to court, you file an application, you file an action in a court of law, you will find that there would be more public access to the documents. But in the initial stage of arbitration, I'm not referring to arbitration enforcement, I'm referring to the arbitration arrangement. It will give a more private or more privatized, more confidential hearing that would enable the parties to arrive at a fair conclusion within a faster period of time. Now, why I emphasize faster is where with the arbitration panel or the sole arbitrator who is appointed, it would be easier for us to lay out the procedure in which we would conduct the arbitration. And as you know, that evidence ordinance has no application to arbitration in terms of the Arbitration Act number 11 of 1995 in Sri Lanka. So because of that, the parties, I mean, that doesn't mean that parties can lead whatever the evidence that is there, but the arbitrator has the right of admission or denial of certain evidence and to look at their credibility. All these aspects are with the arbitrator. But what happens is the procedure-wise, the arbitral hearings can be quicker, unlike in courts where you get a hearing maybe like 2 months, once in 2 months or once in 3 months. But arbitration process can be completed maximum, let's say, for about within 6 months. But that also depends upon to what extent it is contested. Now, in a contested arbitration, it can take a longer period of time. But more or less, these advantages, for example, like the cost factor, the confidentiality element, and the informal approach that you will take in an arbitration would make it more conducive for the people to seek a resolution of their disputes through arbitration. But in Sri Lanka, I mean, as Revan, you will remember that in Sri Lanka we had an issue where High Court wise there was a massive delay in arbitration enforcement sometime back. So because of that, there was a disliking that developed within the mindsets of the commercial sector, as well as the banking sector, and as well as non-banking financial intermediaries who are having an arbitration agreement within their respective loan agreements to move away from arbitration. But now it has been fast-tracked. Now the process is faster. And that is where more the courts are adopting and adhering to the particular procedure laid down in the Act. So it has become more popular and more conducive and more willingly resorted to alternative where parties would feel that it's a much faster and conducive and confidential element of settling or way of settling the disputes. So that I think that would be one of the reasons why arbitration has come into forefront. But if you look at mediation or conciliation for that reason, has very little influence into or very little impact legally. So because of that, like mediation might not be preferred where the small elements or small values will go for mediation. But if you look at certain Chinese contracts will have conciliation clauses, which is more or less before the arbitration process. But then thereafter, they will include another clause to go to arbitration subsequently if the disputes cannot be reconciled there in that process. So finality-wise, arbitration is preferred in because of those criteria. I would say that is the reason exactly why people would prefer, or the institutions would prefer, or the commercial sector would prefer, or the states would prefer in international investment agreements to go for arbitration, even though there are certain bottlenecks regarding the recognition as we go into deeper extent of arbitration, where the seat of arbitration as well as the enforcement of the arbitration award in other countries' wise laws are concerned. But as it stands as at present, it looks a bit rosier than what it was earlier, and where people would find it easier to seek a resolution on the dispute what they have with clarity and faster and with confidentiality.
Thank you, sir. I think another advantage that people prefer arbitration to other forms of dispute resolution mechanisms is, of course, the finality of an arbitration award. And there are very limited circumstances how one can go in appeal. Could you explain that a little, sir?
Yeah. Now what happens is, like, if you say like finality of the arbitration award concerned, but what happens is the enforcement of arbitration, there has to be a conversion of the arbitration award into a judgment and a decree. And in Sri Lanka, you find Arbitration Act number 11 of 1996, where if it is a local arbitration award, the section 31, section 31 would apply regarding enforcement. That is where within 1 year and after 14 days have lapsed within 1 year, and or more or less within 1 year and 14 days, you have to file a petition and affidavit going to arbitration enforcement by filing the relevant documents, including the certified copy of the arbitration award. And that has to be taken into consideration where arbitration enforcement wise, petition affidavit has to be filed, and thereafter, then you get the right, other party will get the right of objection. And also regarding section 32 gives the party affected by the arbitration award within 60 days from receipt of the arbitration award. Now, this is where receipt of the arbitration award buys when you regard as receipt of the arbitration award. It is where section 25 subsection 4, where the arbitrator serves the arbitration award. Arbitrator serves the arbitration award on one party. And that is where the particular period begins to run, the 60 days. So you come into 60 days, where you 60 days, you file an application to set aside. And as you said very rightly, a very, very limited opportunity is given to set aside an arbitration award for a local arbitration award, where you find a party, if you look at section 32, a party to an arbitration agreement was under some incapacity, or like so very, very limited circumstances are listed in section 32. So only on those circumstances, the arbitration award would be set aside. And when you have both applications, the matter where the other section which says is the both applications, section 35 says that if there are two applications for enforcement and setting aside, you will find the consolidation, the both actions would be consolidated. Both actions would be consolidated by the court. So there are application filed to enforce an award and to set aside the award. Both applications would be consolidated. So if these particular provisions are implemented to the rule of law, then I would feel that it would be a faster process where you can get the arbitration award enforced, unlike in another situation where you come into court where regular procedure concerned, it will take a longer time. But whereas not the debt recovery procedure. But what you find is regular procedure actions wise, compared to that, arbitration would be faster. And on the other hand, I would see, Raman, like one of the other key aspects that we both actually forgot is the right of determining who will be your arbitrator.
Right.
Who will be your arbitrator. And you will have a choice of, or you will have the right of selection. Who will be your arbitrator? And other party will also have a right of selection. Who will be my arbitrator? And both parties will get together and select a chairman, the third party or the main party who will be having the right of control of the procedure. And on the other hand, if other party doesn't want to seek an appointment of their own arbitrator, then in that situation, you can always resort to the same arbitrator appointed by the other party and make him the sole arbitrator and continue with the arbitration process. So that could meet the expectations. And if you look at the foreign arbitral awards, section 33 is the enforcement and 34 will apply on what circumstances the foreign arbitration award would be set aside and will not be allowed to be enforced. So those are aspects that we will go into as we discuss.
So on the subject of foreign arbitral awards, I think that's a big advantage there is because under the New York Convention, of course, if there is arbitration that has been done in any of the signatory countries, that can be enforced. So, have you any comments on that, sir, in terms of international trade, to have arbitration as a preferred dispute resolution mechanism? Do you see that to be very advantageous?
Yeah. Now, for example, if you look at the New York Convention, which was ratified by US as well, and where close to 100 countries have ratified that, and where New York Convention coming into effect on 7 June 1959 onwards, 7 June 1959 onwards, where parties have, right of recognition. Now, if you look at the real introduction, the preamble to this particular statute, where in introduction part, it is very, very clearly referring to the purpose. Whereas it is necessary to make comprehensive, if you look at the right at the beginning, an act to provide for the conduct of arbitration proceedings to give effect to the Convention on the Recognition and Enforcement of Foreign Arbitral Awards. So it's very clearly the whole purpose is narrated there. The ultimate purpose was to see the enforcement of foreign arbitral awards. But in doing so, all matters related to arbitration has been covered. And if you look at, even it goes on to say that where it is necessary to make comprehensive legal provisions for the conduct of arbitration proceedings and the enforcement of awards made thereunder. And whereas it is necessary to make legal provision to give effect to the principles of the Convention on Recognition and Enforcement of Foreign Arbitral Awards of 1958. That's the New York Convention, as you rightly put in. So, which came into effect on, as I said, 7 June 1959. So the whole mechanism is where now, if you look at the world trade, the economies have become, due to the digitalization and due to the WWW becoming more popular, World Wide Web, and where the geographical barriers are broken, where countries, you will be in Sri Lanka one day morning, you will have breakfast, you will have lunch in some other country, and you will be able to transact with so many countries while you are present in different locations, because digitally, and where we have the electronic transactions act-wise. So because of those aspects, you will find more and more international contracts coming into play. And with international contracts wise, you need to, as you know, we go to more intricacies, you need to distinguish between investment and international trade. So investment is covered by ICSID, where it is coming to a different process, where more rigid, and where some countries do not adapt to that. But if you look at the other situation, international arbitrations wise, they prefer international arbitrations and to enable recognition, because of the fact that if you do trade and if you carry out a particular arbitration, whereas most of the international agreements now have arbitration, International Chamber of Commerce, ICC arbitration clause, where they say, okay, arbitration sitting or the seat of arbitration would be in Singapore. And where you will decide with neutral arbitrators, where bias would be removed, and where you have no way of saying that they are biased towards one party, and where one country may be in Germany, you may be in Sri Lanka, but the arbitration will be held in Singapore. So where the International Arbitration Act would come into picture and operate it, and you get the arbitration award. Say, let's say it is decided in favor of the German party, and where Sri Lankan party is in Sri Lanka and was given the opportunity to participate, and he was represented. Then in that situation, the German party, in whose favor the arbitration award has been decided, he will be able to get the arbitration award enforced here under Section 33 of the Arbitration Act, get that enforced. That is because this act provides for recognition and enforcement of foreign arbitral awards. So the Sri Lankan law has been developed so as to ratify and adapt to the New York Convention, giving more legitimate situation for foreign international or foreign arbitral awards, where you can get it enforced in Sri Lanka. So, but you look at, remember, like in Section 34, right, it has more areas where you deal with the right to set aside those foreign arbitral awards, which is more or less more powerful element than Section 32. More powerful element than Section 32, where Section 32 is local arbitration award set aside. I mean, it is more or less, it is all elements are there, but these aspects, like if you look at Section 34, a party on the objection of the party against whom it is invoked, if that party furnishes to the court where recognition or enforcement is sought, proof that part of the arbitration was under some incapacity, or the said agreement is not valid under the law to which the parties have subjected it, or failing any indication as the law to which the parties have subjected such agreement under the law of the country where the award was made. So there is more wider spectrum is given where the challenge can be exerted. So that's where the enforcement-wise foreign arbitration awards are not just given opportunity where you can get an arbitration award in a foreign country and come and enforce here in Sri Lanka against a Sri Lankan company. But Sri Lankan company has been given opportunity to deal with that and more or less to identify if it is they were not given the right opportunity, or they were not being given the right hearing, or where agreement containing the arbitration award has a lot of fallacies, and where it was an unfair agreement. And in those circumstances where you will find that you will be able to get away with the arbitration award, or arbitration award enforcement will not be allowed, and it will be set aside by the Sri Lankan courts, which is the High Court of Sri Lanka, which is the Commercial High Court of the Western Province, carry now exercising civil commercial jurisdiction, which is now the High Court number 4, which is specialized.
So to facilitate international trade, still on the subject of advantages, I think there are certain advantages where I'd like to just refer to 2 advantages. One is the fact that you can get specialists in fields of say technology, or fields of say construction or something to also be arbitrators. Is that possible?
Yes, I mean, that is one of the key features or salient factors of arbitration as a whole. Like, it may be international arbitration or domestic arbitration, like, let's say, for example, a construction agreement providing for an arbitration clause. Now, in such a situation where you can get a construction expert, an engineer who has or else a structural engineer or a mechanical engineer who will be having specific expertise in that particular area which is disputed. Maybe you are in that particular construction arrangement, your dispute is regarding electrical wiring, or else regarding electrical conduiting. So in that situation, you can get an electrical engineer who as the particular arbitrator to represent you, or the common arbitrator. So in those circumstances, you will find more expert knowledge can be brought in, unlike in courts, like where you will find the learned judges. With all due respect, there are certain areas where they are not specialists. Obviously, they can take assistance from specialists as witnesses. So in those circumstances, I think mostly arbitration wise, you will have a wider opportunity to bring in experts who will have the expertise and hands-on experience in that particular task to adjudicate the dispute, which would give a right conclusion to the disputants or the parties who are having the dispute. The area of dispute can be properly adjudicated because the other party who is adjudicating has a wider hands-on experience and spot-on knowledge and updated awareness regarding that particular dispute. So that would be a wider or more or less common advantage. But in international arbitrations too, this would be an advantage because of the fact that you can get a set of arbitrators who are experts in that particular field. Now, let's say, for example, you're talking about manufacturing. It is a dispute pertaining to a manufacturing or a particular article where the content or vice. So in that situation, you can get an expert of that caliber into that, or else pertaining to a particular issue on marketing. So you can get a marketing expert coming into that. So in those circumstances, it would be much easier to adjudicate the dispute. I think that's one of the key aspects of arbitration that mostly people, not only domestically but internationally, why it is becoming more popular.
So another small advantage, I just want to know whether you've seen this happen. Now, we live in an international trade, as you rightfully said. Do you see arbitrations now taking place via modern technology such as Zoom, just to facilitate a faster process of adjudication?
Yes, it can. Like, for example, even in Sri Lanka, digital hearing can take place as long as the arbitration procedures, that is where we arbitrate. We have the seat of arbitration in Sri Lanka, and where seat of arbitration in Sri Lanka, where the one party is in another country, and where that party can participate in the arbitration process digitally, and where with evidence that is the party with whom you have the dispute and he has the right of representation. I don't see there would be a barrier per se, but how far it is practically practiced in Sri Lanka, Yes, there are some arbitrations, construction arbitrations, huge arbitrations that are happening. They are digitally taking evidence from experts as well as parties who are living overseas, who needs to give evidence using the relevant, provisions of law pertaining to digital hearings that is permitted in Sri Lanka as at the moment.
Okay, sir. Now that we've covered vastly the benefits of arbitration, another interesting area with regards to arbitration is, of course, the arbitration agreement itself.
Yes.
And that has to be carefully structured, sir.
Of course.
And so, what are the important areas to look at when structuring an arbitration clause?
Yes. Now, I would straight away take you to LG Trade Lanka Private Limited versus Bino Tyres Private Limited, which
Okay.
is Supreme Court case, which is where SC Appeal 106/8 after leave to appeal the final number. And the other one before the leave, it is SCHCLA 37/2008 from HC Civil 247/7 MR, decided by Honorable Justice Salim Mazub with PA Ratnayaka PCJ and SI Mamche on 27th October 2010. Now, this was a particular contract with Bino Tyres Private Limited with LG Trade Lanka Private Limited, which was an Indian company, and there the arbitration clause, the drafted arbitration clause was, any dispute arising out of this agreement shall be referred to the Sri Lanka Chamber of Commerce and Industry, Colombo, for arbitration, whose decision will be binding and final. That was the arbitration clause. Now, Revan, as you rightly said, it was not accordance with Scott versus Avery, 1836, the particular landmark judgment on arbitration agreement. What should be there? Now, what you identify here, there is no place called Sri Lanka Chamber of Commerce and Industry, Colombo. Right. Now, then what happened was Bino Trading, they went to Commercial High Court, or the Commercial High Court, they filed action. That is a regular procedure action, not arbitration. What they took up the position is that this arbitration clause is a fallacy. This is not right. Correct. This is incorrect. But then when the Commercial High Court upheld the position, and the objection was refused from the other party. Other party came to court and took up the objection that no, the intention to arbitrate is there. So the parties had the idea to arbitrate. So in that situation, Section 5 would apply, Arbitration Act, which has a barrier where you can't litigate, but you have to first go to arbitration. So then finally the court decided, even though the arbitration clause had a false element, which is not right, but still the intention of the parties was to arbitrate. So in such a position, court said that there was an arbitration agreement or agreement to arbitrate, though the particular place or to whom the arbitration to be referred to, arbitrator identification or place of arbitration was not right. So in that situation, court said no, but still there was an intention. So even though it was not Avery versus Scott arbitration clause, still there is an arbitration agreement. So therefore, Section 5 would have efficacy. Section 5 of the Arbitration Act would have efficacy, and where it can be you cannot come to court in the first place unless otherwise both parties agree, where you can set aside the arbitration clause. But where one party objects, you have to first go to arbitration and then come for enforcement. So that is this determination. Now, what happens is, regarding the drafting of arbitration clauses, you have to carefully draft it in such a way that where you will recognize what, like all the disputes pertaining to, which is connected to or incidental to the particular agreement, where there is a dispute between the parties which is arising from the agreement, or a connected matter or incidental matter, this will be referred to arbitration with one party giving notice to the other about the fact the intention of reference to arbitration will in writing inform the other, giving, say, let's say 30 days notice to the other party with an appointment of a particular nominating an arbitrator, and the other party is given the opportunity to nominate another arbitrator. And in the event, informing in the reference to arbitration, if you decide to nominate one arbitrator in edit or for you, then both arbitrators shall get together and appoint a chairman, and that arbitration panel would constitute the arbitration panel of arbitrators, and that would would commence the arbitration process. So now what happens is, if the other party receiving the reference to arbitration, the particular provisions will say the arbitration award entered by the arbitrator would be final, but will be subject to right of enforcement within in the applicable provisions of law in the applicable country of enforcement. So that would give you a very clear understanding about how and what dispute will be referred to arbitration and what dispute will not be referred to arbitration. And if you are referring a dispute to arbitration, what is the procedure that you need to follow and inform the other party? What is the mechanism of communication? So even you can put in not only by registered post, but also via email, you can inform the other party so that arbitration agreement can provide. And in such position, other party coming to know of the appointment, so you can also say, this is how the arbitral tribunal will be constituted. And in the event what the other party does not decide to go into arbitration or go into, in the sense, a separate arbitrator, then in that situation, that party can resort to the same arbitrator appointed. And also say that in the event that you all are not in agreement of arbitrators or their dispute, then yes, you can go to section 7, you can go to arbitrator appointment, invoking the provisions of the Arbitration Act number 11 of 1995, where you can seek the court determination about the right panel of arbitrators from and out of several people of independence and integrity by presenting to court, where the court would pick and select who shall be the arbitrator, who will be suitable and who will have the right intellectuality, knowledge, exposure, and necessary skills to determine the particular dispute before the particular arbitration panel.
So, like the example you mentioned prior,
yes,
where you have ambiguity in your arbitration clause or in the arbitration agreement. How does one overcome situations like that, where say the procedure is not set out, the seat is not set out, the rule?
That's a very good question, Revan. Like what happens is, even though now this particular judgment which creates a precedent, even though the arbitration agreement of the parties is callously drafted, and as that, to put it right, that is what you mentioned. So if it is callously drafted, in such a situation, that what happens is, even though it is callously drafted, still, according to this precedent, Honorable Justice Marzouf, with all due respect to the great judge, he went on to identify that parties had an intention to arbitrate. So then in that situation, where there is no clear-cut arbitration procedure set out in the arbitration agreement, parties can write to one another and identify a mechanism how it can be constituted, or parties can come and make an application to High Court and determine the procedure pertaining to arbitration, in the sense under section 7, who will be the arbitrator appointment and what the procedure that they can follow. Because obviously the procedure would be the Arbitration Act number 11 of 1995, unless otherwise you determine a specific procedure where institutionalized arbitration come into play, where like ICLP ICLP rules, where you will resort to ICLP rules and say, look, these are the rules that will be followed. But still further for enforcement, you come into Arbitration Act number 11 of 1995, where the procedure concern, like how you conduct the arbitration. So it will be a matter of procedure where parties will have to agree upon if the arbitration agreement is not clear. But still, the intention to arbitration cannot be negated, cannot be set aside.
Another interesting question in relation to this whole aspect of framing your your arbitration agreement.
Yes.
I'd just like to know what is the difference between, now these terms are used, what is the difference between institutional arbitration and ad hoc arbitration? What does it mean?
It is exactly, it's a very pertinent question once again. Institutionalized arbitration is where you will have a particular institution, like say in Sri Lanka, Institute of Commercial Law and Practice, ICLP, which will be an institution which will have its own set of rules and guidelines regarding the conduct of arbitration. So,
Right.
and also which will have its own arbitration clause, arbitration agreement. So if you intend to proceed to an institutionalized arbitration, then you will set into that particular institution's arbitration agreement or arbitration clause per se. So then it will be drafted in such a manner where the arbitration, you will make a reference to ICLP, and ICLP would nominate an arbitrator, or other party. If the other party writes and say, I too require an arbitrator, ICLP will nominate the other arbitrator as well, and where they too will get together and appoint a chairman that would constitute the arbitration panel. And regarding the rules and guidelines, the ICLP rules and guidelines would determine how the conduct of arbitration would happen, like say how it will commence, and how at the commencement what you will do, statement of claim, statement of response, statement of defense, statement of response. So how these will be filed, and when would the evidence would be led, how, what time periods, all these aspects according to that institution's guidelines in the rules of arbitration. But you have to understand that after you get the arbitration award, then you have to resort to Arbitration Act number 11 of 1995, not only for enforcement, but also for setting aside of the arbitration award. That's under section 32. Enforcement is under section 31. If it is a local arbitration award, so then whatever, whether it's institutionalized or ad hoc, then it's still you have to follow that particular process. Now, what happens is ad hoc is where you do not per se restrict yourself to a particular institution. It may be ICC or it may be ICLP. You do not restrict to that. You will have a wider opportunity for you to determine, or the parties to determine, what would be the procedure. What would be the procedure, or the arbitrator or the panel of arbitrators per se, but the chairman would identify what is the procedure in which he conducts the arbitration. So in that situation, greater application would be, or greater resort would be had to the Arbitration Act number 11 of 1995, the procedure set out therein regarding the impartiality, as well as regarding the opportunity, giving respect to the audio alteram partem ruling, where you find all the parties would be given an adequate hearing, a fair opportunity to put their respective case. All these would be followed, even in ICLP it's there. But what I mean is the ad hoc is where you will determine, the arbitration panel will determine how the process would be conducted. But there, the Arbitration Act number 11 of 1995 has more application regarding the procedure as well. But that is there in both situations. Enforcement and setting aside, you have to come to Arbitration Act number 11 of 1995, section 31, section 31, as well as section 32 in the case of domestic arbitration awards, whereas foreign arbitral awards, it will be section 33 and 34 in concern. That's what the situation would be.
Going back to a situation where you resort back to the act. A dispute arises. One party contacts the other with regards to appointment of, say, arbitrators.
Yes.
And that party is non-responsive.
Non-responding. Yes.
Now there are some sections in the. Could you say? Could you demonstrate what steps you can take in such an instance?
Yes. Now, what happens is when the appointment of arbitrators, if one party is silent, your arbitration agreement, when you are drafting, you can always have that element incorporated. Now, that is where you can say when the reference to arbitration is made, when other party nominates the other arbitrator, and in the event the other party fails to respond within 30 days from the date of receipt of the particular reference to arbitration, that would be deemed an acceptance of the arbitrator nominated.
Right.
So in such a position, the arbitrator nominated by party A would become the sole arbitrator. But on the other hand, where once you regard that party as the sole arbitrator and where you come for the hearing of the arbitration, then if the other party raises a question regarding the impartiality or integrity of that particular arbitrator, that is according to the Arbitration Act, where it takes up an objection that you have been doing this particular arbitration for this particular institution, and your impartiality is at question. Impartiality is at question. Then in such situation, you will find the Section 8. Termination of arbitrators mandatory and removal of arbitrator. The mandate of the arbitrator would deemed removed, where a party would take up the position that I cannot rely upon you. I cannot, virtually trust you. So in that situation, you have to again resort to Section 7, go back to Section 7 and go and make an application to High Court and get an arbitrator appointed or an arbitration panel appointed, where two arbitrators will be appointed with a chairman, and that arbitration panel would be given necessary directions how to conduct the arbitration. So that would be the situation in such a situation. What you asked, I think, did I meet your expectation?
There's another follow-up to this sort of situation where you send notice of arbitration or notice of a dispute, and the other party is completely non-responsive. I believe you can go to court and get a panel appointed.
Of course, you can get. But what happens is, if your arbitration agreement at the time of drafting, that's what I said. If you have foreseen such a situation, if you have incorporated that into the arbitration agreements, within that you say for example, a party who refers the disputes to arbitration shall inform the other party that within 30 days notice, if you fail to nominate an arbitrator, or if you fail to challenge the arbitrator appointed, then in such situation, the appointed arbitrator or nominated arbitrator would fill the seat of the sole arbitrator. So that it can be done, or what you said also can be done, where the arbitration agreement is silent or loosely drafted. Then in such a situation, you can still, for might as well worth, you can come to High Court, make an application by way of petition affidavit and substantiate the position and see the appointment of an arbitrator through the court. So that would give much more resemblance and much more stability to the arbitration panel, which is appointed through court.
Another question that begs some attention is this aspect of interim orders.
Yeah.
Now, does a Section 5 objection prevent you from getting an interim injunction?
No, not at all. Now, what happens is this. Now, let's say I will take you to one of the classic situations where we had a dispute with one of my clients. Had a dispute with one of the developers of apartments. For confidentiality, I won't reveal the names. What happened? There was a dispute pertaining to where the construction process came to a standstill, not due to the particular prospective buyer's issues, but due to the problems that other company had gone through. They went through issues. Then thereafter, let's say after a particular period of time, then they suddenly wrote to the party and said, look, you all have not paid. So therefore, this particular period, you will be given to make the payments entirely. If you do not make pay, let's say, if you do not pay that, we would sell the apartment to another party.
Right.
Now, the same purchase agreement, what they had, there was an arbitration agreement.
Sure.
Now, for you to go to arbitration, the status quo must be protected. Status quo must be protected. Now, if they proceed to sell the particular apartment units, this fellow had 3 units, then in that situation, if they sell it to a third party, then the status quo is not protected. So until the arbitration, you refer the disputes to arbitration, you have referred the disputes to arbitration. So until you have acted on the arbitration agreement, until the arbitration decides on the intricacies of the dispute before the arbitration, the status quo has to be protected. So for that particular purpose, you can come to Commercial High Court or the High Court of the Western Province exercising civil commercial jurisdiction and get a stay order only for the purpose of maintaining the status quo up until the finality of the arbitration process. Finality of the arbitration process, where the learned arbitrator is appointed or arbitrator appointed would determine what the dispute is and would come into a resolution or arbitration award, and then process of enforcement and setting aside happens. So you get a stay order restraining the other party from selling the apartments to third party until such time that particular dispute is resolved, whether the escalated payment has to be made or should not be paid or something like that, or for that particular period.
Right. But the arbitration award themselves, the arbitration tribunal itself can issue interim orders, but that I suppose needs to be enforced.
That doesn't have efficacy.
Right.
That's the problem. So the particular the effectiveness of the interim orders would be other party is bound not to breach it, or if the other party breach it, it would be contempt of court. So in such a situation, if that is not happening, there is no point in obtaining an interim order. So even though arbitral tribunal has the right to make interim orders, the particular efficacy of that order would be at issue. So, but what you have to do in such circumstances where what I brought to you, you have to make a reference to arbitration and demonstrate court that you have acted upon the arbitration agreement. But to the attention of the court, why you are coming before court is not because of anything else, but because of the fact that if we wait till the arbitration finishes, then our status quo will not exist. Then the arbitration would be academic.
I see.
That's the kind of an argument that you can bring in. That's where the Section 5 objection cannot be entertained there. Because you come for a limited purpose. You don't ask the court to determine the dispute. You only ask the court to, the honorable court to decide on the matter and grant you with an interim relief up until protecting the status quo until you and the other party, who are the parties to the arbitration agreement, act on the arbitration agreement and go before the arbitration and come to a conclusion of the dispute, or come to a determination of the dispute, placing evidence before the arbitral tribunal.
Okay. Very interesting. So court at all times respects the intention of the parties to arbitrate.
Of course.
In that respect, sir, now Section 26, I believe, I could be. Section 26 talks about an award being final and binding on the parties.
Yeah.
So that would mean that there is no appeal on that.
That is, of course, the award will be binding. But what happens is, even though it's binding, you have to understand the fact that still, you look at Section 32.
Right.
just like the section 34 pertaining to foreign arbitral awards, it gives the party affected limited grounds, as you said rightly, to set aside the arbitration award. Because what happens is the law has to be fair by all and justice should prevail. So in circumstances where the procedure of arbitration can be and will be flouted by some parties with maybe financial stability comparatively greater, so in such circumstances the party affected would have to have some recourse. So that is why the law, even though 26 says that the award comes to a finality, but still it gives an opportunity, and section 32, come, if you have been affected on these grounds, come before us. We would allow you justice. We would give you an opportunity of a fair hearing. We would set aside the arbitration award. So that is the situation that it stands. And on the other hand, even though it says it's final, still you can't execute it as a writ. So you have to register it within 1 year and 14 days and convert it to a judgment and decree by filing petition affidavit under section 31, subsection 6 of the Arbitration Act, and convert that arbitration award into a judgment and decree. And of course, you will look at the other section which provides the relevant section thereafter, which provides the right of appeal to Supreme Court, where you can go into Supreme Court, where appeal is available. Appellate provision is there, where section 37 is concerned. You can always go to appeal, where section 26, you can see some legislators' minds or the legal drafters' mind, and how it is becoming finality is would be finally in the Supreme Court. With all due respect, like finality would be, if it is contested, finality would be when finally their lordships would decide, and if the 3 bench would come to a 5 bench or whatever, it will be, then finality would be in Supreme Court determination on the respective arbitration award, where it is allowed, where the arbitration award enforcement is recognized, or where the setting aside of the arbitration award is recognized. And I always have Revan, I don't know, this is one of my respective evaluations.
Yeah.
If you have not filed the section 32 application, being the party affected, being the party who has lost in the arbitration,
correct,
I feel that you should not be allowed to file objections against the enforcement.
Okay, right.
Now, that is my gut feeling. But the actor said, when there's an application before the proceedings before the High Court, Part 8, if you look at Section 40, there it says that the other party will file objections. So that is because this act covers all areas, like not only regarding the enforcement, but also when other party files the setting aside of the application, where one party files for nomination of arbitrators, one party files for calling of witnesses, expert witnesses, they are obtaining summons. So that right of objection is more a wider area of that. So the Honorable Court will have to determine in the right perspective. Now, if a party is not satisfied with the manner in which the arbitration was conducted, and if that party asserts the fact that that party was not given the right opportunity or a fair hearing, or that party was not given right notice, or there was a biasness in the arbitral award, or the arbitrator acted biased, then in that position, that party's right has been recognized by the Arbitration Act in Section 32. So if that right has not been invoked, will the law still protect party who sits on his right, or party who sleeps over his right? So in that situation, if you have not filed Section 32 application, from my humble position is that there should not be a position for the other party to object. Right of objection should not be there, where the true meaning of section 31 should be given efficacy. That is the conversion of the award into a judgment. But what happens is this area is not explicitly followed because of the fact that Section 40 procedure under Part 8 of the Act number 11 of 1995, because this Act provides for party to file objections, usually the courts will encourage the filing of objections even when there is no Section 32 application, where one party has filed the application to enforce the award, being the party who was victorious in that particular arbitration award, or in whose favor the arbitration award, the arbitrator has determined the particular dispute. In that situation too, the court permits the filing of objections, which I say is it has to be argued, and finally their lordships in the Supreme Court will have to determine that it is not the right process. 32 application has not been filed. So in that situation, 31(6) application, you have no right of objection. That's what the situation. I mean, that's up to be developed. That situation has to be developed as we passes by, and the way the Supreme Court is now. Their lordships are coming with so many judgments, like we have writ of mandamus, or the latest determinations on writs, and latest determinations coming on injunctions. Like this will also be sorted, I think, if the right party comes before the court.
Now, there is also another interesting provisions in 27. I was wondering how often 27 is used to interpret orders. Is it commonly used, sir? 27 with where you go to before the tribunal itself and ask for an interpretation or an amendment.
Yeah, within 14 days. That's the same way, like same situation regarding judgments and decrees, where civil procedure court wise, where there typographical error, or else the error regarding the certain ex facie elements, where you can come before the learned judge and say, look, this is what the situation has happened, and there's a correction. But the same process, somewhat, in some highly contested arbitrations, I think this is happening because some arbitrators would have may have made errors pertaining to figures, may have made errors pertaining to certain documentary evidence placed before the arbitral tribunal, and where they have identified one document as against another, which is not the right vice versa document. So in such circumstances, the one party who is affected by that can go before the same arbitral tribunal, and bring before the arbitral tribunal, look, these are the lacunas, or these are the maybe shortcomings that are in this particular award, which is where both parties would be there, and parties will resolve, and then an arbitrator can make a determination correction. If the arbitral tribunal considers the request to be justified, if you can see 27.2, if the arbitral tribunal considers the request to be justified, it shall make the correction, modification, or give the interpretation within 14 days of the receipt of the request. So the time period is given, because the arbitrators cannot sit on the particular award and go on a voyage of discovery. So it is very specifically you have to identify what are the areas of change that you are envisaging, and what are the expected corrections that you want the arbitral tribunal to make. And other party will also have to, more or less consent, or if there's any objection, that party will file. And the arbitral tribunal will decide finally what are the corrections, whether the corrections requested for, whether it's reasonable, and which is within the purview, and which is in line with the evidence placed before the tribunal.
Interesting. So now we've spoken on the procedural aspects.
Yes.
Moving to enforcement.
Correct.
Could you speak in brief, sir, how arbitral awards are enforced in Sri Lanka, and what is the process for obtaining enforcement through court?
Yes. Now, what happens is it's the relevant section in Arbitration Act is Section 31. If you look at Section 31, Section 31, subsection 1, a party to an arbitration agreement pursuant to which an arbitral award is made may, within, you get a time period, within 1 year after the expiry of 14 days of the making of the award. Now, you see here, section 32 and 31(6), there is a difference in the terminology.
Right.
We are within 1 year and 14 days of the making of the award. Now, 32, if you look at, it says an arbitral award made in an arbitration held in Sri Lanka may be set aside by the High Court in application made, therefore, within 60 days of the receipt of the award. You see the difference. 31(6), making of the award. 32, receipt of the award. Now, receipt of the award is read in conjunction with section 25, subsection 4. Receipt of the award is read in conjunction with section 25, subsection 4. Now, that's where the honorable arbitrator has an obligation to serve a copy of the arbitration through the arbitration center, of course. So then in that situation, upon receipt 32, then comes the efficacy, or the time period begins to run the 60 days. But here regarding section 31, the time period is a party to an arbitration within 1 year after the expiry of 14 days of the making of the award, apply to the High Court for the enforcement of the award. An application to enforce award shall be accompanied by the original of the award or duly certified copy of such award, the original arbitration agreement under which the award purports to have been made, or a duly certified copy of the agreement. Now, there have been certain cases where the original of the arbitration award was not filed, or a certified copy of the arbitration award was not filed, where the Supreme Court has, their lordships have determined, if valid reasons are provided, still for not even, it is not filed, but a copy is filed, still it is admitted, still it is allowed. But all what you have to understand is you will come to court by way of petition and affidavit. Now, how do you know whether petition has to be filed? Now, that is where your section 40. Section 40 of the Arbitration Act refers to the procedure, that is chapter part 8 of the Act. Procedure. Every application to the High Court under the provisions of this Act, whether by way of appeal or otherwise, shall be by way of what? Petition and affidavit. Shall be by way of petition and affidavit. So always you need you have a connectivity. You have a connectivity. So section 40 is the procedure, and section 31 is the particular provision on enforcement. 31(1) talks about the time period, and 31(2) talks about what are the documents that you need to submit with your petition. And you find it purports to have been certified by the arbitral tribunal if the document or part of a document produced under subsection 2 is written in a language other than the official language of the court or than in English, there shall be produced with the document a translation. Now, say, for example, if the arbitration agreement is in Tamil, and if the language of the court is not Tamil because it's in Colombo, so in that situation, there has to be a English translation that should be provided, or Sinhalese translation that should be provided. Or if it is in Japanese language, so then in that situation, it has to be the particular translation has to be provided. So you will file section 31(6), section 31, you will file the relevant papers where an application is made under subsection 1 of this section, and there is no application for the setting aside of. Now look at 31(6), Revan. Now what I told you is there, is very clearly it's there. Where an application is made under subsection 1 of this section, and there is no, get that wording of the legislature very clearly, there is no application for setting aside of such award under section 32, or the court sees no cause to refuse the recognition and enforcement of such award under the provisions contained in sections 33 and 34. That is regarding foreign awards. Don't forget that. For international awards, international arbitration awards apply for 33 and 34. then it shall, on a day of which notice shall be given to the parties, proceed to file the award and give judgment according to the award. You see here, now the 31(6) does not permit an objection. 31(6) does provide if there is no application made under 31, 32, then in that position, just forget about 33 and 34. You take it with 32. If there is no 32 application made, court shall give notice to the other party and convert the award into a judgment. Now, here, without reading this 31(6) in its real clear meaning, because there's no ambiguity in that section, so there is no interpretation required, they try to go with the section 40, section 41, which is talking about what? Section 40 refers to procedure, and 40 after the petition has been filed. You can see here, every application to the High Court under provisions of this Act, whether by appeal or otherwise, arbitration rather than petitioner shall be named as respondents, and petition shall give notice of the same. Determination of the matter, grant parties named as respondents to the petition a date to state their objections. Now you see in this Act, there is a contradiction between 31(6), 31 subsection 6 and section 40. Section 40 subsection 2.
Correct.
Section 40 subsection 2. Now, section 31(6) is very clear. If the party affected by the arbitration award does not file a section 32 application, it says very clearly, on a date given notice, the award will be converted into a judgment and decree. So, but on the other hand, section 40 subsection 2 says where a petition has been filed, you have a right of objection. You have a right of objection. So that has to be rightly connected, interconnected, and it has to be looked in with 31 subsection 6. And there is a requirement that their lordships in the Supreme Court needs to come out with a conclusion that 31(6) supersedes the position in the 40 objection scenario, where if the other party has not come to court with a 32 application, then in that situation, such party should not get the opportunity to file objections against the petition filed to enforce the arbitration award. So that is an area, a gray area that is wasting a lot of time before the High Court, because if you look at if 31(6) is rightly interpreted and rightly given efficacy, most matters where there are no 32 applications, where you don't need to consolidate under section 35, then in such position where you can go without objections and inquiry, all these issues will not come into picture because of the fact that other party has not challenged the arbitration award. Simple as that. Then your argument of 26 finality would come into life. Section 26 finality of the arbitration award would come into life. So that's the situation that all have to take into understanding, that there is a law which is set and the particular procedure is rightly there. And if you look at the particular act was passed in line with United Nations Convention on Trade Law, International Convention on Trade Law, UNCITRAL Model Law, UN Convention on International Trade Law, UN Convention on International Trade Law. The model law is UNCITRAL Model Law. UNCITRAL Model Law is the basis on which the particular Arbitration Act of Sri Lanka has been structured. And on the other hand, most of the countries' arbitration laws are being developed based on these model laws developed by the United Nations, so as to create, common application, a common scenario in all countries, where you do not have different practices, different rules, different guidelines, which will make it very difficult to implement the New York Convention. where recognition and enforcement of foreign arbitral awards are concerned, where one country's legal framework for arbitration, if it contradicts with another, then the arbitration award made in another country would become null and void in this particular country according to the laws of that country. So in order to get away with the differences in the applicable laws, this ancestral model law has come into picture, and that is the basis on which this Arbitration Act number 11 of 1995 has been structured and is enforced. So that this Sri Lankan Arbitration Act is very neatly drafted, except for some areas like what I pointed you out, 40 section 40 subsection 2 in conjunction with section 31 subsection 6, where it has to be very clearly stated that in such circumstances, right of objection is not there for the respondent, though named as a respondent, because you have not exercised the statutory right given to you under section 32. So if that is there in the statute, lot of delays in arbitration enforcement, award enforcement can be set aside or negated. So that has to be looked into with more prudence and practicality, and that requires a determination or a doctrinal judicial precedent which will be applied. I mean, most certainly in the near future we'll get it, hopefully.
Absolutely, sir. Absolutely. I just want to remind our participants at this juncture to that you can write in the chat and you can forward any questions you might have to Mr. Fernando. Now moving on to the next question, sir.
Yes.
I'm sure this happens very regularly, where you get someone moving for an enforcement, and at the same time, the other party moving to set aside that arbitral award.
Yes.
Now, how is these two?
Yeah. Now what happens is this. Now, when you file a petition to enforce the award, and where the other party has already filed section 32 application, let's say 32 application has to be filed upon receipt of the arbitration award in terms of section 32 within 60 days, where enforcement, you have the right until 1 year and 14 days, from the date of making the award. You understand what I mean? So now both applications are there. Now, when the enforcement application is there with the section 32 application, enforcement application, other party would move for objections. Right. Then enforcement, the setting aside application, that is section 32 application, party who is victorious in the arbitration award would move for objections. So once both the parties have filed their respective objections for the respective petitions that are being filed, one for the enforcement and the other for the setting aside of the award, the court will bring these two matters together, because more or less you are talking about the same arbitration award. One says that it is clear, given opportunity, considered all the aspects, given real opportunity for the parties to determine the dispute, and the parties were given a fair hearing. And whereas on the other side, that's the other side of the story, the party B, who is the party affected by the arbitration award, says, look, no, the opportunity was not given, I was not heard, I was not given an impartial hearing, the arbitrator acted partially, and arbitrator acted in a biased manner. So these are the reasons. So the justifications, the court has before them both the aspects. And then if the court decides, yes, court can go into lead evidence, or otherwise court can determine these both matters by inquiry by way of written submissions, where the respective learned judge would determine what is right and what is wrong, and would identify what are the areas of change that is needed, if at all, or otherwise dismiss the setting aside application or enforce it, or dismiss the enforcement application or give effect to the setting aside application.
Sure. So I just have, one other, just a few other questions. On this aspect of compensation to arbitral, this is going back to the basics once again, right? This aspect of paying compensation to arbitrators, how is that managed from a practical standpoint?
Yes, it's another area or a disadvantage that is coming under section 29, Section 39 governs that particular area, compensation to the arbitrators. Mostly it is jointly or the shared. The cost will be shared.
Okay.
But what happens in Sri Lanka, with all due respect, the cost or the charge an arbitrator attracts depends upon the caliber of arbitrator.
Right.
Right. Let's say the learned arbitrator is a retired judge of the Supreme Court. And then in that situation, President's Counsel and a retired judge of the Supreme Court, the caliber is higher. So the charge would be greater or huge or high. But on the other hand, you get an attorney at law, senior attorney at law as the arbitrator, then the charge would be comparatively less, comparatively, I mean, not much. So in those guidelines, it depends. It depends on the intricacies of the arbitration and the kind of personalities you get as arbitrators and the particular value they attract. So it is up to the parties to identify whom they can afford and whom they can't afford.
But
but there is a disadvantage in that. I mean, sometimes the party who cannot afford would not be able to get the best party as the arbitrator. Oh, that would also be a disadvantage.
But that could be a reason for much disputes in agreeing to who the arbitrator would be, I suppose.
Exactly. So that is one criteria coming into play. But what happens? Most of the situation, if you look at the arbitration agreements are concerned, most of the contracts where parties are into a contract, commercial contracts, most parties have some bargaining power. So in that situation, hardly the payment to arbitrator is hardly contested. But in some situations, they might have an issue. And in that situation where the party with a better bargaining power, sometimes you'll say, okay, I'll bear the cost of the arbitrator rather than me going to share it with you. So in that situation, the other party would not have to bear the cost, where one party would bear the entirety of the arbitrator's cost. But without any intricacies on the biasness, where the arbitrator is not required to be biased on the party who pays the arbitrator. Why the law says that it has to be shared is because arbitrator should not be biased on the party who pays and the party who does not pay. So that's the kind of situation. I mean, I don't say it happens, but what happens is human involvement and human feelings come into picture, where that can be a situation. But I doubt where certain intellectuals wise, the biasness might not happen, where they will decide on the merits of the particular case or merits before them. But in some situations, some parties always have, even before court, this happens or ever. They always say that, the learned judges are biased and learned judges have not given due aspect to their case when the case is not determined right, or when the parties who they are represented, meaning the attorneys at law, with all due respect, sometimes if they are callous or if they are not taking into consideration all the aspects that they should have considered, and they might create a wrong picture about the arbitrator. So in that situation, the poor litigant might feel that he has been played out by the arbitrator, but whereas it is the other way around. So that those aspects have to be really looked into. And whom you select as the arbitrator, I feel you should not be, penny wise and pound foolish. You must always go for a person with integrity, person with caliber, and person with skill, and person with capability, and person with responsibility, accountability, and whom can be trusted. So otherwise, the whole process and mechanism of arbitration would be a futile exercise.
So one last question from me, and then we'll give it to the audience for questions.
Yes.
There is a criticism. There used to be a criticism with regards to Sri Lankan arbitration, that arbitrations take as long as court processes because sometimes the arbitrators match their dates based on their diaries. It's the same people, court goers that go to arbitration.
Yeah.
Has that, can you see it's become faster as time?
Of course, now what happens is this, Raymond, like when you decide, like whoever the parties who are participating in the arbitration, with the arbitrator has the right of determination of the procedure in which the arbitration would be conducted and how often the arbitration would be taken up and how it will be heard. It can be regulated with the consensus and understanding of the parties. So in that situation, like say, for example, say you appear as one party's counsel and I appear as another party's counsel, we can't obviously sit in the mornings because we are in courts. So it has to be in the afternoons and it has to be in the evenings where the time permits. So we can identify what are the times convenient and then go on with the arbitration. Now, what I said is you can be arranged is because you can have always convenient times identified without having much more delays. Like say, for example, in courts, the court have so much of work. But whereas arbitrator is concerned, like maybe the number of the workload might be less. So in that situation, we can identify what are the dates that are convenient. So comparatively, I should say, it's more faster than courts, but compared to regular procedure, not debt recovery procedure.
Absolutely.
Yeah. So that is what prevents most of the financial institutions bringing in the arbitration agreement into their loan contracts or else leasing agreements. Now they have removed most of the arbitration agreements because of the fact that they have the opportunity to go into the other the court procedure much faster than the arbitration process, where you have to have the bite of the cherry two times, one in arbitration, the other one in the high court. So that's what the situation is. But still, I mean, like so many things, I mean, so many areas cannot be arbitrated, but where arbitration is possible, like some matters like construction agreements, where a lot of intricacies, if you come to court, like, if you come to regular procedure, it will take maybe 20, 30 years or maybe 10, 15 years for the final determination. So those matters, yes, of course, you can bring the matter to a finality within the shortest possible time period through arbitration. So like say where say sports bodies have a dispute, where sports personalities have a dispute with the respective authority, where their particular contract has an arbitration clause, then in that situation, going into arbitration has more confidentiality as well as more faster resolution of the dispute what they have. So comparatively still, when you compare it with the regular procedure, then in that comparatively where matters concerning, especially concerning matters like construction arrangements or maybe shipping or construction or whatever commercial matters which require expert knowledge of a party to act as the arbitrator or to act as the adjudicator or to act as the party who decides on the dispute, then arbitration would be the right choice. That's no two question about it.
Thank you, sir.
Thank
So
you.
now we have 10 minutes more, and then we'll, I mean, that's our scheduled time.
Yeah.
There are two questions on the Q&A chat box that has come to my attention.
Yes.
One is on the disadvantages, once again on that where you're measuring the different systems. What would be seen as the disadvantages / shortcomings in arbitration as opposed to regular legal actions?
Disadvantages mainly would be like number one would be the cost. Number two would be there may be unforeseen delays in the enforcement process. And on the other hand, the enforcement process wise, as well as subsequent to enforcement, subsequent to the High Court determination, and setting aside application and amalgamated one determination, still you have a right of appeal to the Supreme Court. So there would be a time factor involved. Sometimes that could be a deterrent into arbitration cost and the longer process it takes to convert award into a judgment and get into the writ. So by the time you get the judgment converted to a writ and you go for execution, the other party will not have assets. So that would be one of the critical disadvantages that this process has. But as at the moment, as at the present situation is concerned, that is not an issue pertaining to the delays wise. Most of the areas have been, nicely covered and looked into, So now the process in the high courts are very much structured, and where short dates are given, one date is given only for objections. So it's now push is created to finish the matters as soon as possible.
Thank you, sir.
Yeah.
Now, the second question, this second and last on the chat box, it says, if I'm to read the question, I think it brings an interesting element. Do the same rules apply for international arbitration? But this gentleman who has sent this question says, gives the example of the Express Pearl case. Express Pearl case. Now there, of course, there was no arbitration agreement.
Correct.
I think there are two elements to this. Application of rules to international, the same rules, application of a law to the same rules.
Yeah.
And the follow-up question to that is, do you need to have an arbitration agreement? So I'd like to impose that also as a part of the question. Your thoughts on this?
Arbitration-wise, unless otherwise, the international convention or whatever that is applicable internationally, globally, provides for that the matter, any dispute on this particular area, the parties have to go for arbitration. There has to be an arbitration agreement where private parties or state parties are involved. Where private or state parties are involved, arbitration agreement has to be there for parties to refer the matters to arbitration. So without the arbitration agreement, parties cannot go into arbitration. But even after the dispute has arisen, if parties still feel that we should avoid court hearing in the initial instance, both parties can come into an arbitration agreement. So it need not be in the same agreement where you contract. It can be a separate agreement to arbitrate. So even if the opportunity is there, after the dispute arises, parties can come into an arbitration agreement and can go for arbitration. So the prima facie requirement is the fact that there should be an intention to arbitrate. There must be an intention. That is where the case what I referred to, that is Bino Tires case, where intention to arbitrate must be there, even though the arbitration agreement might not be sometimes complete or might not be exhaustive, might not be sometimes covering the relevant areas, or maybe incorrect per se. So that's the kind of situation. But still, it is always better to have a fair and clear arbitration agreement drafted, where it will avoid so many delays. And if you look at, like, say, for example, international arbitrations wise, the seat of arbitration where the arbitration is heard, it may be different from the parties who are in the dispute. Say one party may be in USA, another party may be in New Zealand. So USA and New Zealand are two different nationalities or two different nations, which has two different distinct legal systems. Whereas in the arbitration, seat of arbitration, the procedure-wise, the Singaporean law or the Arbitration Act, International Arbitration Act would determine that. So in that situation, enforcement of the award, there's a hybrid procedure in that situation applicable. Hybrid procedure meaning one would be the law applicable in the seat of arbitration. The others would be the laws applicable where the enforcement is made. Now, let's say, for example, party in New Zealand has assets in Australia. So then the enforcement has to be not only in New Zealand, but also in Australia. Another party has assets in Dubai. So it has to be enforced in Dubai. So the particular jurisdictions would differ and the laws will be differing. So there the hybrid procedure would apply. So the parties who are involved would have to decide what is the right procedure that would be applicable. So that should be the situation.
Absolutely. I believe that brings our session to an end, Isuri. I'd like to thank Mr. Fernando for brilliant answers. Over to you, Isuri, to conclude.
Thank you, sir. So this brings us to the end of the 16th webinar webinar of the series on basics of law titled Arbitration Act, a Practical Overview. I thank our esteemed panelist, Mr. Vasanta Fernando, Attorney at Law, and our moderator, Mr. Revan Veerasinghe, Attorney at Law, for the fruitful and educational discussion and for taking your time to be here with us and sharing your insights. I thank PSL Webinars and Legal Symposiums Committee for their dedication and hard work in organizing this webinar. I also extend my thanks to all the participants who have joined in for this session today. Thank you, and I hope you all have a very good night.
Yes,
And,
Suri, I think Mr. Vas-
Yes, sorry, I have to thank Revan as well as Isuri for the continuous, pressure given to me to conduct this. And I have to thank Rajiv as well as our EXCO and all the people who are involved in assisting this particular program. And Revan for the brilliant questions and Isuri for the introductions and real guidance. And thank you very much. And it was a pleasure having this particular session. And I hope I have done justice and what is expected.
Indeed, you have